there was another case that you had told me about, and it has to do with administrative mandamus. And this can be, in the abstract, sound just as exciting as sequel law, but this has a real punchline to it. So here, imagine you have a citizen who's unhappy with an action by the city. Maybe there's a city ordinance that deprives someone of his property or liberty, or it's unconstitutionally vague. Now, your remedy is to file a petition for a writ of mandamus in the Superior Court. But Peter, you had pointed out to me that the citizen's remedy, even if he wins and gets the remedy he prays for, that mandamus remedy may be illusory. What do you mean by that?
Well, unlike in the courts of appeal, where you can get a remand with directions, where the court of appeal tells the trial court, all right, here's how you need to rule on remand. You never get that almost never get that in a writ of mandamus, administrative mandamus case. The courts are very careful, and I think this goes back to sort of separations of powers concerns. The courts are one branch of government, and administrative agencies come from another branch of government, and the courts are reluctant to tell the other branch of government what to do. So the almost universal remedy is simply just to vacate the decision and send it back, and that gives the agency just another crack at the whole thing. And if the legal challenge is, for example, you didn't make the appropriate findings, well, they just go back and they rewrite the decision and make the finding, and you're right back where you started. So it's very easy to win a battle but lose a war if you're not really careful in what the claims you're bringing are, and whether, as a practical matter, it becomes difficult for the agency to rule against you again on remand. But there's very little to stop them from trying. That was an observation that Justice Brennan made in one of the cases I sent you in a dissenting opinion. But yeah, sometimes you can lose the battle and still win the war. That's how easy it is to be a city attorney, and that's right. I've only succeeded once in getting a remand with directions, and that was in a coastal commission case. We were challenging a permit condition, a public access permit condition, which in our view went against the terms of a judgment, a prior judgment, that required this bridge of our clients to be kept private and not open to the public. And there is a severability clause in the Coastal Act, and we said, look, this clause allows you to sever invalid provisions and leave the rest in effect. And the Court of Appeal, unfortunately, in an unpublished decision, agreed with me and remanded with directions. But that's the only time I've ever seen it happen. It's quite rare. So you got to, if you're bringing a writ case and you're advising a client, I'd say, you don't want to bring a claim that's easy for the agency to fix, because you may just be wasting your client's time and money. You want to prevail on a claim that might have a real chance of constraining their discretion next time around.
Well, Peter, when you emailed me with this case, you'd quoted this line: "See how easy it is to be a city attorney. Sometimes you can lose the battle and still win the war." And when you in your email, when you quoted that to me, you had a case after it. Justice Brennan dissenting. I thought that can't really be in a Supreme Court decision, even a dissenting one. But I looked it up, and lo and behold, here's what it says. Justice Brennan, in a footnote, Justice Brennan's quoting a city attorney giving this advice at a conference of the National Institute of Municipal Law Officers in California. The quote is, here's the heading of this advice by a city attorney: "If all else fails, merely amend the regulation and start over again. If legal preventative maintenance does not work and you still receive a claim attacking the land use regulation, or if you try the case and lose, don't worry about it. All is not lost. One of the extra goodies contained in the recent California Supreme Court case of Selby versus City of San Buenaventura appears to allow the city to change the regulation in question even after trial and judgment. Make it more reasonable, more restrictive, or whatever, and everyone starts all over again. See how easy it is to be a city attorney? Sometimes you can lose the battle and still win the war. Good luck." End quote. So that's the footnote from Justice Brennan in San Diego Gas and Electric Company versus City of San Diego. How glib and cynical it is. Now, this opinion was back in 1981. Peter, do you have any idea whether this attitude persists among city attorneys?
What I would say is city attorneys are looking for ways to protect their clients just as everyone else is. I'm trying to be diplomatic here, but mandamus it's an equitable remedy, and even if a public agency loses in the trial court and takes a matter up on appeal, if they then amend the regulation even while the appeal is pending, the Court of Appeal is likely to say that's going to moot the appeal, and that's a special power that a public agency has, because it has lawmaking and adjudicatory powers that private parties often don't. And if the trial court has identified a problem in your decision, and you have the power to fix it and maybe save some litigation exposure and uncertainty, then it doesn't at all surprise me that good city attorneys might advise their clients to be proactive.
Yeah. Well, you had mentioned this goes back to a separation of powers concern on the part of judges. They don't want to. They have to review the petition in front of them, but they don't want to cross the line into telling city councils, sovereigns, how to do their job. Do you think they strike the right balance? You mentioned that sometimes they do issue remand with directions. Do you think they strike the right balance in holding back in the majority of cases, in your experience?
Well, it's interesting to contrast this attitude with what we saw in the Tiburon case, where you actually did have a stipulated judgment, but nevertheless, the judge signed it. And maybe it was because the county in that case at the time thought that was the right resolution, and so the court was less reluctant to be seen to be telling another branch of government what to do. But yeah, I think it tends to be good practice in cases where a public agency is involved to try to get a stipulated judgment where you get a court order at the end of the day, rather than just a settlement and a dismissal. Because city councils change, and but a federal court order is forever sometimes.
Yeah, there you go. Yeah, that's one of the other doctrines, is that city councils cannot bind future city councils.
Yeah, but that is certainly limited when it comes to a city council's decision that then gets the force of a judgment behind it.
Correct.
Res judicata can be even more powerful sometimes.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.